Hello, everyone, and welcome again to Letter of Law. My name is Sarthak Bharadwaj, and I am absolutely thrilled, delighted, extremely honored to be in conversation today with Senior Advocate Dr. Aditya Sondhi, sir. He doesn't require any introduction at all. So I'm going to get started right away. So, first of all, thank you so much for taking time out and being here with me.
It's a pleasure, Sarthak.
Sir, like we were discussing earlier on call when before we sat down to record this, I told you that I've watched so many of your previous videos, and I always find it interesting that you're introduced in a variety of ways. Of course, most prominently, you're introduced as a senior advocate. You're also introduced as an academician, as an author, as a thought leader, and many more things. But I'm curious to know, sir, how do you like to introduce yourself, and how do you see yourself away from these labels and definitions?
That's a philosophical question in one sense, but from the various labels you used, I am essentially a practicing advocate. Everything else that you said is really a bit of an add on. I can't claim to be an academician, though I have pursued my PhD and I do teach from time to time. And I have, I think, a scholarly interest towards the law, to be honest. Nor am I an author in the sense that it's not a professional calling for me. I have written two books and I have written two plays and a few short stories and so on. But honestly, a lot of these things are labors of love. At the core, I see myself as a practitioner with a few other assorted interests.
That's interesting because, sir, from my, of course, very limited experiences with the law, I have realized that those who choose to venture into the practice of the law find themselves consumed by it. It is an all consuming profession. It takes so much of a person's time and becomes a person's entire identity. So do you feel that for practicing lawyers, it's sometimes hard to carve out an identity away from being a practicing lawyer?
See, identity is a strong word. Yes, it is hard to carve an identity outside of it, and one wonders if you really need to do that. For instance, Soli Sorabji, who passed away recently, he had an abiding interest in jazz, in horse racing. He had multiple other interests, but that's not his identity. It's really things he did to keep himself engaged, stimulated, and so on. So one does that at varying levels. But I don't think a practitioner needs to seek an alternative identity. In fact, your identity must be conserved and preserved as a practitioner. I don't think any of the things that you do outside of the practice are meant to dilute your identity. If anything, they should add value and enhance that identity, if anything. And you really do it, I believe, for a sense of self discovery and fulfillment. Um, you don't do it to seek parallel careers or to seek parallel callings, not at all. In fact, anything else that you do must be, with your practice remaining as the priority.
Right.
We can talk about this later if you like. And I know the challenges of doing a PhD while I was practicing. And not once, to be honest, did I ever let my research or my thesis take precedence over the practice. So that, in a sense, makes it much harder for you. So the long and short of it is that you have to keep your eye on the ball, and your focus and your identity, as you said, has to remain that of a practitioner.
So it is interesting how you talked about your PhD also. And in fact, I must tell the viewers, and I was sharing this with sir before we started recording also. In law school, some of our friends, we often jest, it would be wonderful if we could become senior advocate doctors, because these are two incredibly difficult things to do. So Aditya sir is, of course, living the dream that all of us are seeing at the moment. So that's wonderful. But sir, to live the kind of life that you're talking about as a lawyer, as a practicing lawyer, where being one is a large part and a priority of one's identity, one surely has to love the profession. And from all your talks, it's apparent for everyone to see the kind of passion you have for the law and for the practice of the law. uh, This is a very interesting point. I was actually listening to another interview by a senior advocate, and there he said, I don't necessarily love the law, but I love the practice of the law. I'm curious to know, sir, can one love the practice of the law without actually loving the law?
Why not? I mean, look, many of us have been accidental lawyers, so it's not that you set out romanticizing the law or the study of the law. We barely kept our heads above the water. So I suppose that's where this colleague of mine is coming from, that you don't necessarily love the pedagogy of the law, as it were. To be honest, I cannot really read a judgment in a vacuum. I find it most boring. I can only really read a judgment if I have to apply it to a case I'm arguing, or possibly for a lecture that I'm doing or a piece I'm writing. Outside of that, I don't see any joy in reading judgments or articles on the law. I stay away from uh, discussions around the law because, it loops back to the first thing you said, that if you want to have other pursuits outside of the law, then you need to be able to make time for them, and they need to stimulate a different part of your thinking, as it were. And that was really why my PhD also was not on the law. So I think that answers the question, that you can only love the practice of the law if that's what floats your boat.
That's interesting. So now, given the fact that, sir, you are a full-on core practicing lawyer, the core of the conversation for the benefit of the viewers would be focused around those areas. And one question that I'm often wondering about is that, sir, think of a lawyer who hasn't gone to a fancy law school. He or she has been educated in a traditional state university, and upon graduation, that particular lawyer joins a regular advocate in their home state who practices in the trial courts. But now that lawyer also harbors the intention of one day, practicing at the high court of his state, or maybe moving on to the Supreme Court. But from my limited understanding, I feel that to have a practice at the higher courts, one needs to have resources, networks, connections that'll get you cases like that. And it's very often very difficult to have these things if one doesn't have the access that a reputed or an elite law school brings. So a person who has gone to a traditional state law school like this, practicing in a remote part of the country, who wants to move up to the superior levels of the court, what would your advice be to a lawyer like that?
I think there are at least two or three misconceptions in this. If this
Yes.
is what the younger legal community believes, I would like to dispel them straight away. First and foremost, please don't assume that because you're from a so-called elite law school, you're going to have clients and a practice waiting for you. How I wish that was true. I know the hell I went through when I set up my practice, and being from NLSIU or anywhere else made practically no difference. Your work will come as it must. If you're first generation and you're starting up a practice, it makes little difference. Yes, there may be some alumni networks from time to time that may bring you some work, but trust me, it did not fill the void that I had. So if you have those networks because you belong to a certain geography, or you belong to a certain family, or to a certain chamber, and there are many other subtle variables that come into play as to how work comes to a lawyer, which may not all necessarily be merit based. So if you have those networks, you have them anyway. They are not dependent on which law school you've gone to, what your socio-economic background is necessarily, right? The other part of your question was, does it matter if you have gone to one of these NLUs to practice in the High Court or the Supreme Court? Certainly not. In fact, you should take sort of motivation from the fact that most of the NLU products don't practice. So it's in that sense the pie is large. A very small part of that is consumed by the NLU alumni. My batch has about 4 or 5 of us who are in practice, and I think that's generally true of all batches across all NLUs. That number may be slightly higher these days, or that number may be slightly higher in the first couple of years. People begin to leave the race after some time. So to me, I have repeatedly said that this is really a non-starter. Are you telling me the profession was different before the NLUs? Of course not. The profession's been there for ages, and the NLUs are still, in a sense, a startup, right? Maybe 25, 30 years old. Take that consideration or that factor out of your consideration. That's my advice to you. I think there's too much of a mind block. There's too much of mind space being spent on this conversation. And as I've said, I can say it because I am from NLS.
Right.
I'm telling you, the influence or the connection of NLS to my practice is negligible. I have also said that a lot of that has to do with my own deficiencies, that I was a reluctant law student. I was not really interested in being a lawyer to begin with. Therefore, my engagement with the law school also was limited. But that said, practically speaking, if you want to practice, according to me, it should make no difference. I have also said earlier that in some ways you have a head start if you're not from what you described as an elite NLU, because the moment you use the word elite, in my mind, there's a problem. Elitism and the practice don't go together.
Right.
Don't please think that because you're practicing in the High Court or the Supreme Court, you are in some way superior. Some of the best counsel are trial counsel, right? A Supreme Court lawyer may not be able to match the cross-examination skills of a criminal defense lawyer practicing in the Sessions Court. So take that consideration also out of your mind. There is no superiority as to which city you practice in or which court you practice in. Yes, that may be your progression. All of us have tried to grow our practice from the trial court to the High Court to the Supreme Court. I have now set up my chambers in Delhi, in fact, and I'm trying to spend more time there. But that is the sort of progression you aspire to.
Right.
But that said, on a given day, the cases that you do, where you argue them, should really not matter. So, to cut a long story short, let me make this clear that this sort of fixation with which law school you've gone to, where it stands in the hierarchy, etc., is completely extraneous to practice. I mean, that is the conversation that has to be had if you're talking about an IIM maybe or an IIT. How employable are you? How recruitable are you? Where do you stand in the grading? How do potential employers see you? How does that impact your pay packet? All of that is completely irrelevant in the practice of the law.
Sir, I'm thinking about something that you said in the initial part of this answer. You said that you had to go through hell to build your practice and to reach the position that you are at right now. And I'm just wondering, sir, as a first generation lawyer, when you saw others around you with privilege inheriting busy chambers or practices, did that ever lead to bitterness in your mind?
I mean, yes and no, Sarthak. I won't say it made me cynical, because if you become cynical, then there's no point in staying in the practice. I think that is a message that should go out, because you will take a lot of body blows. Even if you're not first generation, it's not that practice is easy. You may have a little bit of a head start in some ways, but the rough and tumble of practice is always there. It's there on a daily basis. Maybe the edges get less sharp as you progress, but it's still a tough and an exacting profession. And does it make you bitter at times? It could. It could. I mean, there are sometimes grossly unfair things that happen to you in different ways in the practice. They can continue to happen to you. Sometimes the outcomes of cases you may think are grossly unfair. And your question about the younger days, yes, I think you're far more sensitive to it. You think that you're in a fair and an equal level playing field. Trust me, you're not. When I started, I thought there would be clients wanting to work with me from day one. That day one became a couple of years before people decided to come to me. And I'll tell you the funny thing, when I set up my practice, the clients who would come to me, the few clients who would come to me, I thought were coming to me because they thought I have some, potential as a lawyer. only two things they used to say to me when they came to me, and they would tell me, maybe they realized I was so young that they could say anything. They would tell me, we're coming to you because number one, we think you're honest, which I thought is a given. The other thing they would say is, we know you're not busy, so you'll be able to give us time. It was such a backhanded compliment that you're not coming to me because you think I have good advocacy skills or that I can, win you a case on merit. You're actually coming to me, A, because you're honest, which was a revelation, because I thought that should be something you take for granted. Clearly, it's not. And that you have time, which also, beyond a point, however busy you may be, once you've taken the brief, you have to be able to give it your all. How you manage your time is your challenge. But strangely, these were the reasons they came to me. And yes, while I sat back, I saw friends and colleagues and junior colleagues who had better clientele, better exposure. They were more recognized sometimes for different reasons, not necessarily because of merit. But I can say this, that you have to rough that out. It's the chambers of Shaolin, as it were. You have to go through that. You have to get cooked on that. And once you sail through those choppy waters, you will find that things begin to equalize. And then I think all of this backstory of which chamber you're from, where which community you're from, are you first generation or not, etc. All that begins to matter a lot less. Luckily, I was from a good chamber where I began. But all of those considerations, which may be there in every court, after a while cease to matter.
Right. So you talked about clients, and that took me back to an earlier interview I was listening of you, where you said that being designated as a senior is, of course, a matter of great honor because the court is trusting you, but it's also a matter of sacrifice because you cannot draft anymore, you cannot argue your own matters, you're ultimately being briefed. Do you miss that sometimes, interacting with clients, making your own drafts, arguing your own matters, seeing them through the end? Or do you enjoy this more advocacy role where you're assisting the court in coming to the right conclusion?
No, I'll be honest, I certainly enjoy this role much more because I found that distance from the client, from the pressure of the case, from the pressure of the nitty gritty of not just preparing a draft, but making sure it's properly filed, that it gets listed in court, following up certified copies of orders, uh, pursuing applications, serving copies on the other side, all of that very hard work that goes into the very listing of a case sometimes, I think can sometimes reduce your mind space when it comes to the focus on research and the expression of the case, the advocacy of the case. So I certainly do enjoy this role more. It helps me, I think, look at a case with more objective eyes and to spend more time developing the arguments and trying to lift the case rather than worrying about the stress of the matter. And trust me, you will see that as a practitioner, that stress makes a big difference. When you're arguing for a direct client, subliminally, the pressure is always on you, no matter what the matter is. Whereas as a senior, you're one step removed. And I think that's I think a great asset to have in your armory because psychologically, you can then see the case for what it is, guide the advocate on record forward, and argue it, I think, with more freedom. But that said, yes, sometimes I do miss the direct interaction, um, especially when I see drafts which are not to my liking. There are drafts sometimes that come to you which you're not settling. They come to you as ready briefs which have already been filed. That then makes your job much tougher because you have to argue the case within those pleadings, right? It's not like you can always amend a pleading. And that's where I sometimes miss the opportunity to have maybe settled that draft myself or to have even drafted it myself. Client interaction, yes, many times, especially if you're doing pure civil matters or criminal matters. By that I mean not writs or public law cases, say partition suits or property disputes or criminal matters, which are fact heavy or even arbitrations for that matter, there sometimes I think the input that you get from the client is invaluable. And I know some seniors in Bangalore who actually refused a senior designation
Wow.
because they felt that I'm thinking of Mr. C.V. Srinivasan, I'm thinking of Mr. Bhagwan. Uh, these are folks who actually turned down the gown because they said, our practice is so pure on the civil side or the criminal side that the interaction with the client is the crux. And you can't then expect me to be dishonest to the gown as well, right?
Wow.
So, yes, you do miss that sometimes. But I mean, look, that's part of the game. You can't have it both ways. If you want to practice as a senior, these are sacrifices you must make.
Right. That's quite something. So moving on, and I haven't talked about this in my podcast because most of the questions that I have come from my own experiences. And since I'm not a lawyer yet, I obviously haven't briefed any seniors. I have never asked this question, but I think I should ask you your opinion on it. Like you said, there are some drafts that come to you which may not be of your liking, and you do not even get an opportunity to settle them. So when lawyers come to brief you, sir, what are some things that you feel briefing lawyers should keep in mind before going to brief a senior? How can they make it more effective and help the senior in better understanding the case?
See, I would say that a briefing counsel should imagine in their mind that they are appearing in court. Now, if you're appearing in court with that brief, you will necessarily need to have your facts on your fingertips. You will need to be ready with the law, and you will need to respond to questions well. So, in that sense, a briefing with a senior is like a rehearsal before the court. And you should be open. You should not mind uncomfortable questions. And I always say this, to some advocates on record who I find getting slightly uncomfortable with my questions. I say, look, these are the questions the court might put to me tomorrow. And if we are ready with those difficult parts of the case now, you will have an easier run in court tomorrow. Your chances of getting an order will be better, right? And advocacy in many ways is response to questions. It's not that you argue from page 1 to page 200. Courts come red, especially if you're doing matters in the Supreme Court. The window is extremely small. I had a matter yesterday, court was inclined to issue notice. I was for the respondent. How do you block an interim order unless you try and say the absolute right thing at that second? And it's hard, right? Now, that is where sometimes I think you need to, as a briefing counsel, be a little open. If there are weaknesses in the case, there's no harm in identifying them before the petition is filed, or if the petition is filed, to at least identify them in the conference with the seniors, so that if there's scope to repair it or to address it in your arguments, you'll be the better for it. I believe that good briefing notes really matter. By that I mean crisp briefing notes. Sometimes this word synopsis has lost its meaning now because synopsis is sometimes longer than the original draft. But I'm happy if the briefing note is crisp, 2 to 3 pages, gives you the annexure, gives you the page number. So it's things like this, Sarthak, that I think matter. Briefing counsels have an important role to play. It's not that you just leave it to the senior and sit back, That's not how it is, because you have to ultimately face the music in court, right? Of course, the senior is the front. So you face the fire, you face the tough questions, you take the case home in a sense. But many times there are aspects of the case which you as the filing counsel or as the instructing counsel have to own up to. Whether a particular document is filed or not filed, or I remember once there was a matter where my senior had sent me to brief a senior.
Okay.
And some very uncomfortable questions came from the court about some parallel litigation the client had instituted which had not been disclosed. And I was sitting back merrily thinking, I have a top senior, he'll take care of me. And at that point, the senior counsel, Mr. Narsimurthy, incidentally, R.N. Narsimurthy, one of the tallest seniors I think the Karnataka bar has produced, not just for his standards as a lawyer, but I think for his ethical standards. We can talk about that later. Mr. Narsimurthy looked at the bench. I think it was Justice Baruka's bench, and he said, "My lords, these are questions my friend will be able to address." And I saw stars, you know. And of course, I, as an independent lawyer, decided not to brief seniors. But I can tell you from this experience and more from my experience as a senior itself that it's not that you can just sit back and take a free ride. That's not how it is. You have an important role to play, and that's why the more you own up to the brief, the more you confront the difficult parts of the brief, be open in a conference, the more prepared you are. I think the better the outcomes will be.
That's interesting, sir. But it leads me to another question. Now, of course, it is a fact that being designated as a senior by a court is a matter of great honor. It means that the court trusts you and will agree more with what the senior is saying. However, there's often a saying that's said, once a particular lawyer is arguing, it's more about the face value rather than the case value. And it's often said that, if there's a senior on one side and a normal lawyer, I mean, a non-senior lawyer on the other side, the senior might sometimes get away with arguing a tricky position of the law that may or may not be accurate at all times. Do you feel that somehow the bench needs to balance the trust that it reposes in a senior plus the opportunity that junior members of the bar deserve?
Look, trust has to be earned. Let's make no mistake here. It's not that a court is going to blindly rely on you just because you're a senior.
Sure.
No. Of course, the designation process entails an assessment of you not just as a professional with skills, but as the Advocates Act says, your standing at the bar is also a factor.
Right.
Now, your standing at the bar is really a subjective assessment that the full court makes. And inbuilt in that, I think, is your fairness and credibility as a counsel. So, to that extent, yes, the process of designation entails a sort of a character certificate almost to a senior. But that said, the designation process also now, as you know, after Indira Jaisingh's case, has changed. As a result of that, the assessment process has become more objective. And we are also seeing a far greater number of lawyers being designated as seniors. It's good in one way. The flip side of that is that if you have more seniors, then necessarily each senior has to earn his or her stripes in court.
Right.
It's not going to be a given that anything you say will be accepted. And you can see this in court. You said face value. Face value has to be earned. Face value is when you tell a court that a particular document is at page number 166, and the court takes your word for it without going to page 166. But if that document is not at 166, or the document at 166 is not what you said it is, trust me, that face value is gone. Because the judges are going to go back, meet over a cup of tea and say, oh, Mr. So-and-so or Miss So-and-so is a misleading counsel. Please be careful. And trust me, that is a message not only to a senior, it's a message to any lawyer,
Right.
senior or not. Especially, I think, to a younger lawyer, because that's where you can mess up your credibility and face value and reliability as a lawyer. So let me say this. Yes, a senior may get more space possibly to a certain extent, but I have fought cases against lawyers who are junior to me at the bar. Sometimes they have come up trumps. Many times they acquit themselves better than us. I'll tell you this, the hunger that you see in a young lawyer makes a big difference. So that should not really matter. I think the bar is getting more equalized now because you have more seniors. Therefore, the onus is greater on us. And I have to dispel this misconception also, because a lot of people think that if you engage a particular lawyer and he or she stands up, the rest will happen. Yes, I mean, look, that might happen. In some cases, in some courts, yes, it might happen. But that's not the rule. I still believe in the better definition of face value, which is a value that you earn over the years by court seeing you day in and day out and trusting you that you will not cite a judgment that is overruled,
Hmm.
that you will tell the court sometimes that you have no case, right? That is also part of the face value process. When you speak of assisting the court as a senior,
Right.
that is also part of the process. So, in a sense, excuse me, in a sense, your aspiration should be to earn that face value.
Hmm.
Face value is not necessarily what your last name is,
Yeah.
or who your father was, or where you're from, etc. That's the wrong face value. If it's there, it is there to some extent. That's not the face value I'm emphasizing. It's the other.
That's a very interesting point. So moving on. So I am seeing this conversation these days that litigation lawyers are saying that one has to build a brand around themselves. And people are very active on LinkedIn, law chambers have websites, they're active on Twitter. Now, I'm not saying these are bad things. I have personally gained a lot from lawyers writing blog posts or writing an analysis on a judgment. I've greatly benefited from it. But what is your take on litigation lawyers wanting to build a brand around themselves? To what extent is it relevant in today's age, or should lawyers focus more on their work and not become content creators of sorts?
Look, let's again define what we mean by brand. I
Right.
think if you mean brand as an identity, that's the word we used earlier in our conversation. I think all top counsel are a brand in that sense. They
Absolutely.
have an identity and a reputation and a style, even that is unique to each of them. And that is really the end game. But if we mistake brand to mean a corporate brand, then I have a problem with it. Our code of conduct precludes us from soliciting clients, from soliciting work, right? Soliciting is a subtle word. It doesn't just say advertising or marketing. Soliciting could be veiled marketing also. And that is not a path I think that is not a path one should go down. Maybe what I'm saying now in some way is dated because a lot of people seem to do it. You spoke about LinkedIn, etc. Of course, you can have a social media handle and express your views. In fact, that is one way of the march of the law, as it were. And if you enjoy writing about the law or speaking about the law or expressing yourself on larger socio-political things, that's very much part of your role as a counsel. You're in a public profession.
Hmm.
But that cannot become a place for you to advertise your work, what cases you've done,
Yeah.
um, posting photographs in robes outside courts,
Right.
etc. I don't think that is the sort of brand I am comfortable with. You know that the code of conduct for counsels also says that you will not wear your robes outside of a court,
Oh,
right?
really?
Yes, please read it up. There is a lot of detail in that code, and I think people should live by it. You say your podcast is called Letter of the Law, isn't it?
Yes.
So please look at the letter and the spirit of the law. There are every single prescription in that code has a deeper meaning to it. Your role vis-a-vis the court, vis-a-vis the opponent, vis-a-vis the client, conflict of interest, material interest in cases, etc., etc., is very detailed. The very size of the name board that hangs outside your door is prescribed. And why is it? Because there is expected a certain dignity to the profession. And I realize this apparently does not have much resonance these days, but that doesn't matter to me. I live by it.
Yeah.
And to me, it is crucially important. And I think at some point, people will realize that we need to collectively maintain not just the standards, but I think the decency and the dignity of our profession. Only then we're the better for it. And that is where a lot of this comes in. And I don't think then it should become an unfair playing field, because then what happens really, Sarthak, is that if you have a Twitter account with many followers and you are brazenly publicizing your work and really soliciting work, you have an unfair head start over somebody else who doesn't have that. Somebody who may be a better counsel than you also. Or you have a head start over somebody who is adhering to the code of conduct and not doing it. And that takes me back to your question. That is where the bitterness can sometimes come, that I ought not to be paying a price for doing the right thing.
Yeah.
Right? Right? It's
True.
not that you want the bar council to haul up your colleagues. I don't want to go that far. But I think introspection, self-regulation is important. And
True.
that is where I think brand building sometimes gets misinterpreted. Your brand, really, Sarthak, let me tell you, your brand is how the court sees you. Your brand is not how big you talk to the external world
Right.
on your Twitter handle. That's fine if you want to do it. But your real brand is what the court thinks of you. And I've said this before, more than the judges, it's what your colleagues at the bar think of you. That's the toughest judgment. It's
Right.
the most ruthless, and I think the most also the most objective judgment that is made of you. Why do I say that? Because colleagues see you every day. Even judges only see a glimpse of you. Judges see you in court when you're arguing, but your colleagues see you day in and day out. They know dimensions of your personality which maybe even your family members don't know. And the bar is opinionated, as it should be, as it should be. And therefore, if you're really concerned, I know I'm giving you a long answer, but
No. Please go on. Please go on.
No, I will conclude by saying this, that if you're really concerned about your brand, let your brand be what your fellow members of the bar think of you. If you have a brand there, I think you've done well.
That's a really, really interesting take, sir. And I feel I'll put this clip as a separate video in itself. But, sir, another question that comes to my mind from your answer is that the true opinion which matters is that of the bar. And in one of your previous interviews, I was listening, you've said that the law is the only profession where a lawyer's merit is tested out in the public. They are out there in the public eye, in front of the court. There are other people sitting behind you, listening to you. And since people will laugh, people will pass comments and say all sorts of things, how does a young lawyer begin to learn how to block out that noise and focus simply on that brief and to assist the court? I feel it can be an incredibly difficult thing to do, but what are your takes on that?
Yeah, and before I answer that, let me say now with hearings being online live streamed, the glare is even sharper. And I have recently written a piece which should be published where I've spoken about this new order of online hearings. And I've said that with hearings being on YouTube, of course, there's transparency and greater engagement with society at large. But there's also a little bit of tabloidization of the court process happening. And that's not necessarily because of the system, but you will find on YouTube sometimes some very obnoxious captions given to a 2-minute clip that's happened in court to make it more sensational, or to run somebody down, or to puff somebody up, none of which should happen. So the glare is sharper, and in that sense, yes, for a younger lawyer, the public glare, the pressure, in a sense, I think is greater now, because more people are watching you, and they're watching you for posterity, because whatever you're saying is now going to be recorded. All those mistakes and bloopers that I made from my years in court, which have gone away unnoticed, maybe an opponent would have poked a hole in it, or a judge would have had a laugh at my expense. At least they're not recorded, right? But today, if it's there to see, it can be embarrassing.
Yeah.
But I don't think it should still deter you, because in a way, that is why you join the profession, right? You join it of course, for the justice delivery that comes with it. But you also join it, I think, for the performance that comes with it, the thrill of arguing cases. And yes, you need to have a thicker skin up front. Sometimes you can be humiliated in court. I remember days in court where I could not sleep,
Mm.
simply because a little comment that a judge made or an opponent made would sting me. But then you begin to also develop a thicker skin. What I mean by that is that you have to let things slide. My senior would sometimes say, brush it off. It's something on your gown, brush it off. That's it, and move on. Um, it's not that it should make you complacent. You have to reflect on how to improve your skill set every day. But also, you don't have to take everything personally.
Mm.
And the earlier you learn that lesson, the better. I took personally, I think I took too long to learn that lesson. I took too many things to heart. I let more things affect me than they should have, to be honest. You realize with the passage of time that you're in it for the long haul. I mean, I'm not 24 years at the bar. I'll show you people who are 64 years at the bar, right? So the wheels keep turning, and you have to therefore go a little easy on yourself. That's what I would say. There's no harm if you make mistakes. And let me also say, then there is an onus on us as seniors
Mm.
to cushion you. If it's my junior who's arguing and he or she is getting a tough time in court, then it's the onus is on me to sit down with them in the evening and say, it's all right. You did your best. You could have done this slightly differently. So keep that bond also going. It's a two-way street. It's not that juniors are to be left thrown to the wolves. In fact, I think as a senior, our obligation extends to all juniors, not just to our own. If we can encourage somebody who's argued well in court, have a word with them, sometimes correct them also. Sometimes I take the liberty, I don't know if I'm right in doing it or not, of even telling younger opponents that, you know, you could have avoided saying this. It can be slightly patronizing. You may not like it if, you know, your opposing counsel is telling you, but you have a role beyond the case. And if somebody's done something sharp, you know, like annoyed a court or said something blatantly false or offensive, I think in the corridor you can take 2 minutes and try and correct them. And sometimes juniors do welcome that also. So I would say that, you know, you're not entirely on your own. You will have kind judges who look out for you. You will hopefully have kind opponents. You will have kind seniors. I'm reminded of the anecdote that Justice Gautam Patel used to remember his senior, Mr. Settleward, I think was his senior. And when paying tribute to him, he said that he sent me once for a matter to the Supreme Court because he couldn't go. And he said, oh, don't worry, Ashok Bhai and Soli will take care of you. Meaning Ashok Desai and Soli Sorabji, if I remember the details. No, so listen. So Justice Gautam Patel said, but Ashok Desai and Soli Sorabji are the seniors appearing for the other side. But his senior said, no, don't worry, they'll take care of you. And that is, I think, the beauty of the bar, that beyond the case, beyond winning an order, getting an order, it's not about scoring brownie points. Even within that arm wrestle that you're in, if you can look out for the other side, you can have a little, it's tough, yeah. I mean, it's aspirational. I wish all of us could do it better, could walk that talk. But there are instances of it where people rise above. I have experienced it where my seniors, sometimes my opposing seniors, have spent time in the court. I can think of Mr. Raghavan, who's a leading senior of the bar here. So many times when we've done cases against each other, and not now, when I was a junior, he would take a minute after the matter to come and say a kind word, to say that you did well. And that means a lot. I think of Mr. Yoga Narasimha. I'm sorry, again, I think I'm rambling, but
please go on. That's the whole point of a freewheeling conversation. I guess. Go ahead.
think of Mr. Yoga Narasimha, who's no more, and I did a tough RSA, regular second appeal against him, which had a very complex question of Muslim law involved in it. And it was before Justice Gopal Gowda, who was then a sitting single judge in the Karnataka High Court. And I managed to argue it and have the appeal admitted. And getting an RSA admitted is tougher than getting a first appeal admitted, because an RSA can be admitted only on a question of law. There has to be a substantial question of law. After it was admitted, I remember Mr. Yoga Narasimha met me in the corridor And he said, "You did extremely well, young man, for your age." I
Wow.
was over the moon. And he said, "Let me also give you one piece of advice, which has stayed with me." He said, "Don't repeat your arguments." And that's a mistake a lot of us make. Even now, I make it. We tend to think that the court has not got the point. So you want to make your best point over and over again. But actually, every time you repeat it, you dilute it. And I'll be honest, I also find it difficult to adhere to this. It's kind of a natural tendency to repeat yourself, but you try harder and harder, at least not to repeat more than once or twice, right? And I
Yeah.
remember his words still, and he was absolutely right that, maybe I had a point to have the appeal admitted, but I didn't have to, drill it home over and over again. It's not a moot court.
Yeah. Right.
I think I'm getting into trouble by saying that.
Not at all.
Yeah. I'll stop here. Yeah.
That's really wonderful, and this makes me believe that though the legal profession is adversarial, ultimately all opponents are our learned friends, as the lawyers call them often. And just for the benefit of our viewers, before I move on to the next question, since we talked a little about online hearings, sir has another video on YouTube where he has talked about these things, and I'm going to link it in the description box. So if you want a fuller discussion on that topic, please watch that video. I learned a lot from it, a lot of things that I did not know before.
And I can just add a little caveat here that was a talk I did in the very early days of online hearings. And I have, in fact, and I was frankly skeptical about its success. And as much as I stand by everything I've said there, I have also gone on record later to say that in the working of the online hearings, a lot of things have proven me wrong. A lot of things have led to an improvement of the system as well. There are, and if you take time to watch that talk, you will see that there are certain areas that I've tried to highlight where I think online hearings take away from the profession, and I stand by those. But I have been enlightened over the last 2 years to see also the brighter side of it, which is the efficacy, the ability to argue cases in other cities, in the Supreme Court online, the saving on time and cost, etc. And I think all of that is to the credit of the system.
Right. And so, sir, moving on, sir, about the legal profession, it is often said that if you want to litigate, of course, the first few years are going to be extremely difficult. There's going to be very little money and so on. But we were also told that eventually it gets better. Stick it out and things will start getting better. However, sir, I don't know if that's true for everyone. Not all the lawyers who stick it out are going to be designated senior. Not everyone is going to earn the monetary returns that the legal profession makes a person dreams about. So, sir, given this background, what would your recommendations and advice be to a young lawyer to not make certain mistakes, which in the later years will hold him in good stead and ensure that his practice reaches a point that one dreams of?
Look, you have to do a reality check here in the sense, I mean, how much money is enough money? You have to also define for yourself what your aspirations are.
Right.
Right? You want to make money, yes. But do you want to be rolling in money in 3 years' time, or do you want to be also doing good quality work? Do you want to also be doing pro bono work? You repeatedly spoke about wanting to be a senior. Today, with the new guidelines in place, the amount or the quality of pro bono work you do also is important.
Sure.
Your academic side has suddenly become important. It was not earlier. It's not that any of us thought of writing articles. I didn't do my PhD because I thought it will help me become a senior. Of course not. But today, actually, you have to tick all those boxes. Also, being a senior does not mean the be all and end all of your profession.
Right.
As I've said, it's a new start. If you become a senior, then you have a greater onus on you. You have to deliver as a senior. Work has to come to you as a senior. Is that also not important?
Yeah.
So the challenges will remain. They will come back to you in different ways. That is it's going to ease up in a sense, yes, but it's not also going to be a cakewalk. You can never sit back, and I think that is the charm of it.
Hmm.
Can a surgeon say, I'm going to have an easy surgery? No. Regardless of your experience or your skill set, that surgery that morning can mean life or death. And you have to bring your A game, right, to the
Right.
table that day or to the park that day. So I think you have to do a reality check. If you want an easy ride, don't come to practice.
Yeah.
Let me make that very clear.
Yeah.
You have to be ready for the challenges, and you actually grow to enjoy them. Things will ease up in a practical sense. More work will come, yes. The money will improve. The recognition will improve. The bonhomie with your colleagues will improve. How important is that? It's not that people are waiting there with garlands to welcome you.
Yeah.
How long did it take? I think you said NLS. Nobody cared I was from NLS. I didn't have friends at the bar when I joined the bar. I had resistance. It took a long time. People maybe thought I was offhandish. It took time for me to unlearn things. It took time for people to warm up to me. All that will take time for those glass ceilings to be broken. But let me tell you this much, that there's no real safety net in practice.
Yeah.
It's like your IPL eliminator, which I think happened yesterday. It's this way or that.
Right.
That is the in some way the thrill also and the risk also of the profession, that you can't expect like a cozy middle path really. And I would not even encourage you to go that way, because then you shouldn't become a safe lawyer. By that I mean it shows in your personality. If you go to court, you have to be ready to lose, right?
Yeah.
Every day, I don't care who you are as a senior, sir. Every day, if you're going to court, you want to win your case, but you have to be ready to lose it. So where's the safety net? There may be calibrations. Some cases are, allowed in part. You get via media relief. Sometimes you're only arguing for interim relief, etc. But at the end of the day, there is something you're playing for that you may not get. Now, therefore, your demeanor and your very body language has to then express or show that you're up for the fight. But if in your spirit you're playing safe, then frankly, I don't think then the profession is really for you. You will find it difficult. More than that, you may not do justice to the profession. You may not do justice to your clients also, right? At the end of the day, if you're being engaged, senior or not a senior, you're being engaged to go to court to get some order. Now you have to fight for it. Sometimes you will get it without fighting also. Your case may deserve it, or one short point may do it, but you still have to, in many cases on a daily basis, grapple for your relief. And therefore, I would say, look, it's a tough question. There are many dimensions to it, but to say this, one thing, I will say that you need to have that sort of that fighting spirit to take on the profession. If you don't have that switched on, it won't work.
That's a really inspiring answer. So thank you so much. It's going to take me a bit to process that. But I'm reminded of something that you said a little earlier, sir. So you talked about when you went independent, you chose to argue your own matters and didn't brief seniors. Now, with that regard, sir, if a young lawyer is thinking of joining a chamber, what would your recommendation be? Should a young lawyer choose to join a senior advocate, or should a lawyer join a chamber of someone like you when you went independent, who's arguing their own matters, doing a little bit of briefing on the side, drafting on the side, interacting with clients also? What's your take on that?
I would say 100% the latter. As a raw junior, what I mean is someone fresh out of law school.
Yeah.
You're better off not joining a senior counsel. You ought to join a reasonably senior lawyer. By that I mean a non-designated, but a lawyer with reasonable seniority and experience. Typically somebody in their late 30s, let's say, who has a good practice. Again, it depends on what area you want to practice in. So that you're exposed to exactly the things you said: drafting, evidence, client interaction, strategy, provided your senior lets you in on all this. Again, you have to pick a senior who has that comfort in giving you that much space, right? Different seniors have different styles. And most importantly, the opportunity to argue cases. A senior counsel can't delegate their brief to you. I am not being engaged and being paid a fee by a top law firm to delegate it to my junior, right?
Sure.
I can't. Even if I want to, I can't.
Sure.
But a lawyer who's not designated has that liberty to hand out a brief. And I used to try and do that with my juniors till I became a senior, to let them argue their cases to the extent I could. I mean, I am a bit of a control freak. So I found that little difficult in the High Court, to be honest. My juniors will all endorse this. But I tried. I tried to, at least in the trial matters, give some of my juniors a free run, right from the filing to the leading of evidence, all the way to final arguments. No,
Wow.
that is really the skill accumulation and the training, right, to become a lawyer in the long run. Whereas I think you should look at joining a designated senior maybe a little later, maybe a 2-3 years. And I don't think this is imperative either. It's your choice. But if you do want that exposure as well to a senior counsel's chambers and that style of advocacy, then I would think a couple of years later is a better time to go there, because you already have your basic skill set. Then you can focus more on, preparing a brief to brief the senior, a greater emphasis, I think, on research, and an ability to focus more on the advocacy. In some ways, this may sound like what an intern does, I'm afraid to say. But that's the way it is. And I make no bones about it. There are so many juniors who have come to me who I have advised not to join my chambers because I feel they should get a different type of exposure. And equally, I have had very good juniors after being designated who tick these boxes extremely well. And I think it stands you in good stead, because then you get an all-round skill set. But yes, beware of just joining a senior because they're a big name. Because yes, you may be following those matters and you may be in court, as you said, you may be tweeting about them, etc. But what is your real exposure to the advocacy and the learning, I think, still remains.
Thank you so much for your take on that, sir. So, sir, since I've already taken a lot of your time, let me come to the final question for the day now. So you've spent several years being a lawyer, as a non-senior, now as a designated senior advocate. What is your take, looking back on all these years, as to what a lawyer should do to get successful? I know it's a very open-ended and a tough question to conclude, but just in all these years, what are the wisdoms that you've learned that you can sum up in a few minutes and offer to our viewers?
That's almost a spiritual question. Very hard to answer, to be honest. I think I've tried to cover some of those things in my earlier answers. But what is it that jumps out to me is, be ethical. It's extremely important. That will, it's a marathon. After some time, what is it that distances you from the other runners? What is it that propels you a little forward in the long run? I think is your ethical standards, basically your professional ethics, for which you need to first know what your expectations are as a professional. I'm hoping that the law schools you go to spend time on that course. I'm afraid they don't in many cases, but they should. And if you have a clear understanding of what your professional ethical expectations are and you try and adhere to them, I think straight away you will have an advantage. Beyond that, I think you have to enjoy the profession. It's not something you can do under any duress. It's not something you can do because your parents want you to do it, or it sounds fancy, etc. You won't last. Let me not mince my words. Or even if you last, you'll be an unhappy soul. So you have to actually revel in the challenge. You have to enjoy the grit of the profession. You have to enjoy the rapport with judges and your fellow lawyers. It's tough, but you have to try and develop that. Uh, and I would say you should focus on being a court-facing lawyer as best as you can, because people tend to always offer shortcuts. There are no shortcuts. People try and offer via medias, but take a long, hard look at what type of advocate you want to be, and try and be that court-facing lawyer if you can. Once you do that, you will start visualizing yourself. And you have to therefore be on this journey of self-discovery. Let me tell you, it's not that you suddenly arrive one day. Yes, you will find exponential changes. You may be doing very little work for 2 years. You may suddenly be doing a lot of work every day thereafter. But that said, there are no destinations here. And you've got to therefore try and be on this process of self-improvement. And if those things matter to you, I think the profession is great. Beyond that, I think anything I say will be a general answer. We can talk about it some other time.
Great. With this, we can come to an end of today's conversation. Sir, thank you so much for taking time out and speaking with me. I got to learn so much and I thoroughly enjoyed myself. Thank you so much for your time.
Thank you, Sarthak. Thank you for having me.